Welcome everyone to XA's Open Cases report to launch. We ask that you keep your questions till after the presentation. You can then either raise your hand or you can type your question in the Q&A. Donald, you can get started.
All right. Hello, everyone. I'm Donald Mackay from XA Global Trade Advisors, and welcome to the launch of our second import duty investigation report. The last one came out around 6 months ago, and this is kind of a follow-up on what happened last time and where we are at the moment. So import duties are imposed typically because there's a domestic producer who feels they require protection from import competition, or alternatively, it's removed or some kind of duty relief is given when the product that you wish to import is not available locally, either in sufficient quantity or at all, or the wrong quality, etc. All of this then runs through a body in government called the International Trade Administration Commission. So you go to them, motivate for your position, they would investigate, and they would take a decision. And this report really deals with the amount of time it is taking from once that investigation initiates to when a decision is taken, and the fairly significant economic consequences of how long many of these decisions are taking. In all fairness, though, I met on Monday with some senior folk at ITAC. We've had a number of interactions with the DTIC, and there does appear to be a commitment following our last report to reduce the amount of time that it is taking to finalize these investigations. So my opening paragraph in the report that all of you will receive at the end of this meeting is, if you love localization more than you love ice cream, then getting trade policy working properly is for you. And really, this is not to debate the question of whether our localization policies are good or bad, but simply to say that if you want to make them work, whether by reducing the input costs of raw materials or adding protection to the finished goods, then the process has to work. And my analogy is going to get a little tired here, but let's run with it. So using my ice cream example, the cone would be the process. This is the structure that is required for these investigations to work. And then you can pile on top of that whatever flavor policy that you like. What is, however, certain to not work is if the process itself falls apart. And we're in a position at the moment where we will present some firm evidence that there are fairly serious problems with this process. But like I said, also encouraging to know that this is receiving proper attention. So I'm going to kick off with a very simple example, because so much of what this report talks about is really this encapsulated in the story of this one company. So Matador is a butchery in the Eastern Cape, in a small town called Somerset East. In 2010, they set up a factory to produce chicken kebabs. And the way they make this is a little bit different. As a raw material, instead of using deboned breast or deboned chicken thighs, they instead make it with a deboned leg quarter. For whatever reason, the market really liked that, and they were doing well. In 2010, they employed 90 people working in their factory. At that point, they were importing chicken leg quarters and paying a 12% duty. Now, in 2020, those duties were increased to 42%, so 3.5 times as high as they were before. And they lodged an application to obtain duty relief on that product for as long as they couldn't obtain it locally. To support their application, they attached letters from around 70 domestic producers of chicken, not one of which was prepared to supply them with deboned chicken leg quarters. Now, that application is 17 months overdue, and they now employ 25 people for 2 to 3 days a week. So a substantial decline in performance. Now, we'd say Matador, it's a tiny business in the middle of nowhere, not that big a deal. But in 2010, they were the third largest employer in town after the municipality and the hospital. And of course, whether Matador survives or Matador fails is not going to be the determining factor on what happens with our economy, but it is a microcosm of what is occurring. And this report really takes that and gives you all of the detail on the scale of this problem. So I want to put up some numbers for all of you to engage with. The first is we currently have 1.4 billion rand, which has been paid in duties when people have applied for duty relief for a product that is not available locally. So when we calculate that 1.4 billion, we look at the period an investigation has been overdue, and overdue is deemed to be after 6 months. Now, the 6 months is not arbitrary. This is the policy position. You can go to ITAC's website and download it, and they will say there that the target is to wrap these investigations up within 6 months. So we count from month 7, and this report cuts off to the 31st of December, and then we say how much duty was paid in that overdue period. And in this case, it was 1.4 billion rand. And what matters here is that money can never be recovered. Even if tomorrow all of these duties were removed and that was deemed to be the right decision, the 1.4 billion rand is simply no longer available to those companies. And bear in mind again that there may be some of these investigations which legitimately say we don't want to grant the duty relief, but we're dealing here with the cost of indecision rather than the cost of a conscious decision, which we may debate is right or wrong. On the other side of this, we deal with duty increase applications. So here we have an applicant. The stated reason kind of follows roughly the same path every time. We're struggling to compete with imports and insert for whatever other reason. If these duty increases had been granted, and again, I'm not arguing that they should have been, but simply to say if they had been granted, 1.6 billion rands worth of duty would have been collected, assuming the trade patterns kind of remained roughly consistent. And so we've got somewhere around 3 billion rand just tied up either in duties that should have been paid or potentially duties that should not have been paid. It is an enormous amount of money. The 1.4 billion is particularly alarming to me because the decision for duty relief is very easy to make if you can't obtain the product locally. When you're dealing with the duty increase, there will by its nature always be a disruption. So the nub of duty relief should really be around the question of whether a product is available or not. So I'm going to bring you now to the next example. This is the oldest current investigation that is open. In 2018, Nature's Garden approached ITAC for a duty increase on frozen mixed vegetables. I'm going to leave again the question of whether they absolutely required the protection or not, but they certainly argued that they did. So if you look at the chart at the top of the table, you will see data goes back to 2015 that they provided to ITAC. And you can see at that point that imports were busy increasing. You'll see where we are now. The import volumes have moved in the opposite direction. And in fact, we now import less than we did at the start of the process in 2015. To give perspective to how problematic a decision on this would be if taken now, in the time since information was provided, we've had 9 CEOs at Eskom. Of course, Andre de Ruyter should now be added to that list. Brexit has occurred. President Ramaphosa was voted in, and then again. We had the March on the Capitol in the US. We had lockdown start. We had lockdown lifted. We've had Russia invade Ukraine. We've had 5 UK prime ministers. And all of this is to say that if you were to take a decision on this investigation at this moment, it's very hard to see how you could arrive at a rational decision, whatever it may be. And this kind of just demonstrates why these investigations have to be dealt with close to the time when the information is in front of the regulator. So this case is as we speak now, 46 months overdue, which we're heading for 4 years overdue on a decision that should have taken 6 months. Now, it's also possible that this investigation has in fact been resolved. So there are occasions when private settlements are reached. So what this means is perhaps Nature's Garden has met with ITAC, was met with Minister Patel, and they've agreed to not proceed with the duty increase. The problem is those settlements are never published, and that creates a legal problem because no other person can apply for any kind of action on this tariff code while there is an open investigation. So right now, we're dealing with worrying levels of food inflation. If someone decided that they wanted to apply for duties to be removed on this product or simply reduced, they would find that to be a very difficult problem to solve because this case has to first be terminated. And in fact, not only does it have to be closed, it has to be closed for 6 months before the next investigation can be brought. So where we do have private settlements, it's absolutely essential that the settlement be published, the reasons for it be published, and that the matter be closed so that it can be properly noted as no longer being a current investigation. So if you look at this table, our first report dealt with the numbers in the kind of 2 left-hand columns, and the current report deals with the numbers in the 2 right-hand columns. All of this detail is explained in the report, but perhaps the most important component of all of this is the average months that the investigations have been outstanding for. So we had 42 open cases on the 30th of June last year, open for an average of 18 months. We have fewer investigations open now, but they're on average open for a longer period, this time of 22 months. We've created an open cases index, which is not that important except for those that really want to climb into the detail here. But the index was created to allow for a heavier weighting as cases get older. So in other words, the average is not good enough. Very old cases are much, much harder to resolve. And so what the index does, using some exponents, it allows us to create a disproportionate weighting to very old cases. And that can kind of give you a sense of what that position is currently looking like. If we look at the number of overdue cases, so these are everything more than 6 months old, the number of overdue cases has dropped, but the average period that these have been overdue has gone up. In other words, we're not resolving the older cases fast enough. And that is a particularly difficult problem to solve. So I'm going to show you some more information here. This is the distribution of open cases at the moment. The bar on the left-hand side are the cases that are open and not overdue. The cases in blue are those that are open, they're overdue, but no more than 12 months overdue. In other words, they've been running for 18 months. And here, we're still close enough to the information where we could make a decision now, and it's not going to be utterly irrational. But the minute you get to the orange block on the right-hand side, which is 56% of the open cases, we're in very, very difficult territory here. And the further right you move, the harder that problem is to solve. And one of the recommendations we make here is that either where the case is simple to resolve, in other words, is there a local producer or not, ITAC needs to get official comment from the applicant and quickly make a call on those decisions. For those that are harder to do, I think we're better off simply terminating those investigations. ITAC can do an immediate reinitiation, call for new information to be provided, and make the decisions. But leaving these overdue for longer and longer, as cases migrate to the right, they are going to be harder and harder to find elegant solutions to. So all of this really talks about a rather large problem, which is we don't have a predictable process. So part of why everything takes so long to get wrapped up is that the process itself is completely unpredictable. So when we go back to the Nature's Garden example, if we had spoken to Nature's Garden 4 years ago and said, would you like to bring your duty increase application? We understand the import volumes are increasing, but it's going to take 4 years for us to make a decision. If we create that environment, people will opt out of the process because whatever happens 4 years into the future no longer connects to what is happening in that moment. So for trade policy to be in any way effective, it's absolutely crucial that it is also agile, that it moves along a predictable process. The outcomes, somewhat ironically, need to be unpredictable. So what this tells you is when I engage with this process, I'll present my arguments. ITAC will consider those arguments, and they'll also consider the arguments of other people that participate in that industry. And they will then arrive at what they believe to be the best outcome. And that's a good process. We don't want to go to court, for example, being completely unaware of how that process will unfold. And even more alarming would be if you absolutely knew what the outcome would be. So we want a situation where processes are very predictable, outcomes need to remain unpredictable so that the investigation can arrive at the correct conclusion. The unpredictable process and the very, very long amounts of time these investigations take is starting to result in fewer people participating in the process. And we'll put some of that data up in a few minutes. For now, we're proposing that deadlines be built into the legislation, and we're proposing a 12-month period to say at the end of 12 months, if an investigation has not wrapped up, that it automatically needs to terminate. There can be no conceivable reason I can think of where the quality of the decision is improved by waiting 24 months, 36, or heaven forbid, 48 months to make a decision. And so if a decision cannot be made in 12 months, then I can't see that a better decision could be made by waiting even longer. Part of the delay, which I think is a legitimate reason for the delay, but is still problematic, is public interest is forming a larger and larger part of these considerations. Public interest considerations, I think, are absolutely essential when these sorts of decisions are made. But in fact, our legislation doesn't require any public interest consideration when an investigation is considered. We've seen Minister Patel exercise public interest considerations. If we're looking in August last year, the minister said, ITAC found that there was dumping of chicken out of Brazil and some countries out of the EU, but I'm not going to impose those anti-dumping duties for a year because I believe this would inflate the price of an essential food item. And so I think that's the fact that consideration was made is a very, very good thing, but it isn't a requirement. I would argue we'll all be better served if public interest became an absolute requirement in these investigations. And I might add, many other countries around the world have public interest as an absolute requirement before duties can be changed. Reciprocal agreements are probably, certainly our guess is, the biggest factor causing delays in tariff investigations. So here's what a reciprocal agreement is. You go to ITAC and you say, I have a factory that uses this particular raw material and I can't get it locally. I'd please like to not pay the duty on this raw material. And ITAC would finish their investigation and perhaps recommend that this duty be removed. Now, before the removal happens, that applicant company will be presented with an agreement that they're expected to sign. And that agreement would say, You agree to not increase your prices beyond CPI for 3 years. You agree to employ a certain number of people. You have to invest a certain amount, or whatever other requirements are finally imposed. And so what the reciprocal agreement does is it imposes a cost to implementing the decision that's been deemed to be optimal. Now, I do get there's a counter argument to that, which says, well, it's still for the good of the business. If you, for example, begin training more people or investing more. But of course, a counter argument to that would be that you would do that anyway, if that's what was deemed best for your business. Without further debate on the content of reciprocal agreements, the fact that they're introduced, and particularly that they're introduced right at the end of the process, adds time. Some companies don't wish to sign them. And of course, that could create a delay. It's also entirely possible that refusing to sign the reciprocal agreement might result in the benefit never occurring. So the duty removal that you needed on your raw material, or the duty increase that Nature's Garden requested, might be withheld if they don't sign off on the agreement. Once the agreement has been signed off, this is no guarantee that the investigation will be finalized rapidly. We have an investigation now where the reciprocal agreement was signed a year ago, and it took a year for the benefit to be implemented. So the reciprocal agreements certainly slow the process down, but signing those agreements off is not a guarantee that the process would move quickly. But they also create another distortion in the market. So that the applicant is the company that needs to sign this reciprocal agreement. They are the ones who commit. They have to get feedback every 3 to 6 months to the minister or to ITAC to say, this is what we have done to ensure that they comply. Legal action is confirmed if you don't comply. But the other players in your industry may not be required to sign such an agreement. So what we're doing is we're adding a cost to applying rather than adding a cost to the industry. And that, of course, makes it very unappealing to be the guy who puts pen to paper. The agreements are kept confidential, which makes it very difficult for us to assess the economic impact of the agreement. So if the thought behind the agreement was that this agreement will create more value than the cost extracted by having this agreement, it becomes impossible for any kind of independent economic measure to be made of that, because the content of the agreement is not in the public domain. The agreements, of course, are typically not met with wild enthusiasm from industry, but they are a fact of life at the moment. And we certainly think that the conversation around these agreements, we understand that they are government policy at the moment, and we have to live with them. But the way they are currently managed, I do believe is causing more harm than good. If reciprocal agreements, for example, have resulted in the bulk of these delays, then we have to say, would signing these agreements, would those commitments create greater economic value than the 1.4 billion that we've extracted in duties? And bearing in mind that you can't get the 1.4 billion back, that becomes an unlikely outcome. The net result of all of this has been a precipitous fall in the use of these instruments. I'm not going to attempt to attribute causality and saying that because of reciprocal agreements, this is the reason these are falling. But I think the combination of these factors is resulting in a very significant drop in the use of all of these instruments. And that could be because people find it unappealing to be going through this process. It could be that nobody is up for a 4-year process when it should be resolved within 6 to 8 months. But whatever the reason is, there is a drop in the use of these instruments, and that has quite far-reaching implications. If we're going to say to companies that before you can make your investment, you just have to live with the cost of this duty on a raw material you are unable to secure locally, then a certain portion of those investments will not happen. Those who are marginal and where those duties make the difference between the investment happening or not happening, it will have an effect, and we believe it is already having an effect just based on some of the conversations we're having with our own clients and prospective clients. When a duty has been imposed or duty has been removed, we don't have an automatic process to review these duty changes. And this kind of becomes particularly striking if you consider decisions that were taken before COVID and where we are now. Those decisions may have been perfect at the moment they were taken, but we're in a very different world at the moment. And we're recommending that all duty changes that were affected in the period running up to COVID should simply go through a mandatory review. ITAC should publish them for review, take comments, and even if they arrive at the same conclusion, that conclusion would be arrived at with new information and updated information. And then a final comment, we have to get clarity on the role of the ministers. So we have, if you speak to most people who work in this space, they would tell you the final decision maker in any of these investigations is the Minister of Trade. But in fact, there was two court cases in 2016 where the Minister of Finance argued that, in fact, it was his decision. He made the final call, and the court agreed with the Minister of Finance in both of those cases. And we have had some cases delayed on the Minister of Finance's desk. So, for example, the two cases that went to court in 2016, both of them went to court because the Minister of Finance was sitting on the decisions for too long. At that point, Minister Rob Davies was in charge of trade. And in fact, Minister Davies agreed that from receipt of a decision to implementation, he had committed to no more than a week. But the Minister of Finance was not prepared to make such a commitment. And so we either have to take the court's decision and bake it into our regulations so that everyone knows what happens here, or alternatively, if we believe that those decisions are problematic, then Parliament needs to consider an amendment to the legislation so that the responsibility is accurately allocated. And that, folks, is all I have to say. If you have any questions, Arista will coordinate them. I'd love to hear from you.
There are two questions from the Q&A. The one is from Consultancy Hub. They are asking, what legal remedy does industry have on overdue applications? Are the timeframe legally binding to ITAC and the Minister? And what, if any, is Parliament holding the ITAC and the DTIC responsible and accountable on their performance?
Yeah, so the problem we have here is there is bizarrely no legal requirement to ever complete a tariff investigation. The requirement is, if there's a prima facie case, they have to investigate it, but there's no legal requirement to ever complete it, which means they can stay open for as long as you like. And it becomes a really difficult instrument to enforce because of this. So the very simple answer is, it is very difficult to legally enforce compliance with this, which is why we're saying we have to build this into the legislation so that it's not left open-ended. There are no timeframes that are legally binding. I'm not sure what Parliament are doing about this at the moment. I mean, that's an important question, and we'll be sure to pose that question to the chair of the Parliamentary Oversight Committee. But we do think this is an important problem to solve. And again, to come to the defense of both ITAC and Minister Patel, there does appear to be a very clear commitment dealing with the problem, and that's encouraging. So I think we also have to give them some space to do what they're committing to do. When we publish our report 6 months from now, we'll of course be able to see has the direction changed, and I really hope it has.
And then the next question is from Francois Frashia. He's asking, do we know what the equivalent experience is in other countries of these processes?
Yeah, so some of it, we with tariff investigations, they don't come with the structure that, for example, the WTO prescribes anti-dumping investigations. And so they are kind of left open to the country to deal with how they wish. So Francois, the simple answer is I don't know what the experience is in other countries, but that too is an interesting question. We have strong relationships with lots of consultancies who do this work around the world. I think I'm going to get an answer to that, and once we have it, if any of you follow our blog, we'll post the answer to that on our blog, and you can read what we've uncovered in a few weeks' time. Does anyone else have any questions? No one? All right, very good. All of you that have attended will get the report, a PDF of the presentation, and the recording will be up on YouTube, I would guess, by early next year. Oh, here we go, Tokozani. So Tokozani's questions: HS codes can cover a multitude of things, especially if we look at other. Let's say I have a product that falls under 76, 10, 90, 90, other structures of aluminium, for example, which pays a 10% duty. Will a new HS code maybe be created to cater for that item if not available in SACU? So Tokozani, the answer is yes, it could be. Absolutely, those happen all the time. We account for a lot of those changes. All of those other codes in the tariff book create problems, but they're also an essential part of the book because we trade an infinite number of goods across borders, and we have 7,500, give or take, tariff codes. But the answer is yes, a new code could be created, and which would attract a different level of duty. If you need help with that, let us have your details, and we'll speak to you on how that can work. Anyone else?
There are no further questions.
All right, guys, you have our details. If you have questions you'd like to ask at another time, give us a call, send us an email, and thank you very much for taking time out. Cheers, everyone.